So, perils of expert evidence in PI. There's been a lot of criticism and as well as good work of expert witnesses. They are valuable to the court process for matters that the lawyers are not experts in, or the judge isn't an expert in. However, the things can go awry, and especially in the process that we're in. Certainly, so far as the high court, higher value matters are concerned, arguably they tend not to go to trial itself and often settled before then, whether in JMCs or on the papers or otherwise. But some of them do go to trial, and there are some significant judgments in that regard for over significant sums. But there's also, of course, the more volume end of, say, RTA arena, which also has implications in terms of the multitude of litigation that does actually go to trial. And whereas it might not be the massive millions of pounds, cumulatively it adds up because up and down the land, these volume cases are going on. And that's what I'll also focus on. So in terms of the outline, I'm just going to cover the duties of expert witnesses, and then some High Court examples, and then with an example regarding volume RTA PI of a case that I've been instructed in and acted throughout, recently published. You can find it on Westlaw. There's the reference, and it's a county court decision. I'll be dealing with that. You may be wondering, why is there a guillotine axe and a head plate? We shall see. Now, as far as the duties of experts are concerned, you can see there that CPR 35, for example, point 1 to point 4, covers the duties, and particularly there. And in particularly 35.3, it's the duty of experts to help the court on matters within their expertise. So, of course, not to stray outside of their track. And this duty overrides any obligation to the person from whom experts have received instructions or by whom they are paid. So it's not a hired gun for hire, not supposed to be partisan. The overriding duty is to the court. Now, you have there at 3.1, 3.2, I don't need to read all that to you, the what a report must contain. And just focus, for example, on number 6, where there's a range of opinion, matters dealt in the report to summarize the range and reasons for their own opinion, and so on. Importantly, at the bottom of that slide, the experts must be aware of the requirements of Part 35 and the PD and guidance. Now, there's, of course, the statement of truth to add. Just in addition to that, in terms of more recently, you'll note that the SRA has a reminder about expert evidence in high volume work in May 25, and they've also, within that, although that largely concerns surveyor work and high volume housing disrepair type cases where there's been some movement of late, it also refers to Medco concerning PI issues and so on. And in that regard, the organisation used to source the material, Medco, have also some guidelines in April 25, which you have. And in that regard, they include making sure that examinations are not carried out in solicitors' offices. That's the Medco. Not in a hotel bedroom, for example, but in a suitable professional environment. And the Medco also, you'll note in their point, you can see there, suggests a maximum of 35 examinations in a day for these experts, and a minimum of 15 minutes spent face to face with the claimant. Guidelines only, of course. I must say, 35 in a day, that just goes to show that, the volume of cases that one could be dealing with. That's probably about 9.5 hours straight back to back of appointments. And personally, I'd have thought that's still a massive number. And So often we get at trial, the witnesses saying, "Well, I didn't say that to the expert. I said something else, and they got it wrong." And you know, the defendant, the claimant counsel may say in submissions, "Well, it was just a 15-minute examination. Bit of a rush. Hey, uh, experts make mistakes." Uh, that shouldn't be the case because they, of course, have a duty to check their reports, and it should be checked even by the claimant before it's litigated in the various pre-action protocols. But still, there it is, 35 in a day, it seems. Of course, the following subjects to be discussed face to face, and at the bottom there, the account, the circumstances, the injuries, the progress since the accident, received treatment, and so on. When I say progress, injuries since the accident, so often in cross-examination, when inconsistencies are put to a claimant from a defence perspective, the claimant may say, "Well, I thought I was only being asked of how I felt today during the examination," and clearly that can't be the case because it clearly is since the collision and as well the prior history. Now, further, in terms of duties and responsibilities, we have the shortly titled Care and Reefer case, which has a number of bullet points. You can see in that regard, and it's His Lordship Cresswell, Justice Cresswell, Parils 81 to 82, identify key principles and responsibilities of expert witnesses. This is a summary, it's not verbatim, but number one, the expert it should be independent, a very important consideration, clearly. I cite there the case of Maepa. It's been around for a couple of years now, but still, it's worth citing that at paragraph 287, Mr. Justice Cotter said that some care experts have a full-time private practice solely preparing reports for either claimants or defendants. Given that the compilation of the care report often requires a significant amount of subjective judgment, there is an obvious risk of contravention of Cresswell J's first principle and CPR 35.3 in brackets 2 through the lack of true independence arising from the need to maintain a source of instructions and the pressure to prepare a report which is favourable to the instructing party. Also, paragraph 304 of that particular expert concerning there, after I asked her report to contain no breakdown, Miss Kirby revealed that she had been preparing reports solely on behalf of claimants for 9 years. She recognised an understandable concern a court will have as to the risks that arise when an expert's workload and income is solely for one side of litigation. And in my view, the risk came to fruition, and the reports she prepared contained some partisan views designed to maximise damages for the claimant rather than recommendations made, as they should have been, after balanced and objective application of the relevant principles. So, very damning there in terms of a consideration of breakdown of work. However, in balance, some would argue that it's difficult to measure how much work one has. If you've got a percentage breakdown and comparison, is the expert to say, "Well, I've reached what I think is a reasonable amount that I should do for one side, and now I'm going to have to refuse work for the rest of the year from that same side, hoping that new work will come in from a different side." So there is a difficulty there, clearly, but still, where it's so overwhelmingly excessive in one side, that I'm sure is a factor to take into account. Number two, the expert witnesses should be unbiased opinion, in relation to matters within their expertise, that's to say, staying in their track, and never act as an advocate. Important, and we'll deal with that a bit later on as well. So you can see there the other uh, considerations in the if case, all the way down there. I think I've got a bullet point number 7 that's repeated as 6, but should be 7. And there's also, it's largely reproduced in the practice direction at the bottom there, 2.1 to 5 and 3.2 in brackets 8, largely, not verbatim, but this is largely there. And in practice, a an expert must be open to correcting factual inaccuracies and clarification, mustn't deviate from their original opinion, but should constantly remind themselves through the litigation process they are not part of the claimant's or the defendant's team. Their duty is to the court. And so, of course, it needs to be well researched. And as I say, there is that difference between the high value cases and the volume cases, whereby the volume case, well, in fact, both sides of experts perhaps arguably might think they're never going to get to court because on the volume sense, if you're doing 35 a day as a maximum, and we do see certain experts repeatedly on certain issues up and down the land, the jurisdiction, they may think, well, in reality, how many of those am I going to actually be called to court in? And equally, in the high value cases, they may think similarly, how many am I going to get called to court in? But the trouble is, for all experts, they must be prepared to go to court and justify their opinions and come up to scrutiny. So, in that regard, just by way of an example, there is the Samurai and others case late last year, High Court. And in this regard, it's a case concerning sexual abuse allegations, and expert Dr. Blythe, clinical psychologist, instructed by Seas. Now, the reality is there that the judge, Mr. Spencer, paragraph 250, found that Dr. Blythe had failed to include the statement required in the practice directions, namely that she was aware of the requirements under Part 35 and the guidance, the practice direction, as well as CPR and the expert civil claims instruction guidance 2014. At paragraph 2451, she had not complied with the CPR 35.10. She did not include a statement of her report that she had understood and complied with her duty to the court. At 252, there was no statement in some of her reports of the substance of her material instructions, nor was there an appendix, list of documents, nor, as is mandatory, a summary of conclusions. In terms of the duty to the court, a factual dispute as to the existence of a room where alleged abuse is said to have taken place and that was quite visible, open to glass, I think it was a matter for the court to determine. However, Dr. Blythe included in her report her own supposition that the room could have been disassembled after the arrest of the accused. She accepted that she should not have put that in her report, but the judge took the view that she had lost sight of her role as an expert and her duty to the court. She, at 255, it said that she copied paragraphs of her report from an article by another, and which was not acknowledged, so in other words, plagiarism. She did not include the article in the list of materials relied on, and Mr. Justice Spencer, his lordship, said that it's difficult to imagine a more blatant breach, not just of the provisions of Part 35, the PD, and the guidance, but more fundamentally, an expert's obligation to the court, because these passengers were, in fact, a deception practiced on the court by Dr. Blythe in pretending that these passages were her own words, representing her own opinions. Damning. And further, paragraph 256, there's a whole history that she took of the claimants, she said, but didn't put that in the report. She didn't think it was important, yet her opinions relied on that history. At 257, it said that she accepted in cross-examination that she had come to court and attested the truth of her reports without reminding herself of their contents. In other words, she hadn't read and prepared the documents and the reports for the trial itself. She also accepted this was not acceptable as an expert. And further, there were a number of inaccuracies, or at worst, misleading, it was described as, paragraph 260. So there, something went terribly wrong with an expert, and I suppose the allegations there of were very serious allegations. It's not the stuff of volume, which is what I'm now next going to turn to, in terms of, and just take a moment to read first of all, before I do that, the rejection of Dr. Bly's evidence. Mr. Martin Spencer, totally rejected. So I'll now turn then to the more volume end and the county court. And here we're talking about issues, for example, since the changes between tariff and non-tariff injuries, the proliferation of all sorts of other injuries than simple whiplash or travel anxiety that would be common to those issues. Now we seem to be talking a lot more in terms of claims anecdotally. I almost think you can almost sing the song. I know I can't get feedback, and I can't hear whether you think this is good or not. But there's that song, isn't there, which you can put to this now, rather than just whiplash. It's now a matter of heads, elbows, knees and toes, heads, elbows, knees and toes, and CBT, and you can go on and on and on. In that regard, we now have the case of Basharat and times two and Colazo, 2025. It's only recently been formally handed down in the beginning of September. You probably won't have heard of it yet, even though it's reported on Westlaw. But the difficulty is that it's in a queue for them to do a summary for the front page of the Westlaw article, but the judgment is there. Until they do that summary, it probably won't get picked up by your various search feeds that people will have on Westlaw until that summary is done. So in reality, this I introduced to you as the first time that it's being publicised as the case that I was advocating in, as instructed by Aviva through Miss Chloe Chung of DWF. So here we have a simple side shunt from a T-junction. The claimants are in. It was certainly a collision that could have incurred injury. The claimants instructed Mr. Matthew Akal, a psychologist. They claimed soft tissue injuries and psychological injuries. C1 ultimately was awarded limited injury damages. C2, potentially had injuries and was found to have had some, but was struck out under Section 57 of the Criminal Justice Courts Act 2015. However, of significance in terms of expert witnesses, and indeed Mr. Akal, is that the background of Mr. Akal's evidence his evidence was rejected. The background is that presently there is a Healthcare Professions Council outstanding proceedings with interim conditions of supervision regarding Mr. Akal. Yet to be tested in court, but the HCPC's expert has criticised Mr. Akal's work, but that's yet to be tested in the final hearing. But for the time being, District Judge Jawson found that for expediency and for the benefit of the claimants, rather than waiting for his disciplinary proceedings, it's better to proceed with the trial before the county court, which is really in any event a higher jurisdiction in precedence. So, the Mr. Akal was described in the judgment, and I've put the paragraph references there if you get the copy from Westlaw, that he had appalling behaviour in a 2017 employment tribunal case. The difficulty he had is that, and I'm going to take me a while to read this. So you wondered why you had the guillotine. Well, it's because it is clear that his conduct, in paragraph 21, the Judge Dawson said it's clear that his conduct in the 2017 Employment Tribunal case of Mr. Racco was appalling, and his expressed views as to the court and various judges rendered him wholly unfit to be an expert witness. I do not understand how this was not disclosed to the HCPC, either at the time or subsequently prior to the incident proceedings before the HCPC, for them to properly investigate it. He was dismissed in his employment, such dismissal being the initial subject of the 2017 Employment Tribunal matters. The case was stayed until June 17, and thereafter Mr. Akal wrote a series of emails to the court, including accusing various members of the judiciary involved in having narcissistic personality disorders, suggesting that they referred themselves to their religious leaders and then to the police, and suggested that they would be beheaded by the royal family. That's 28th of June 2017. He sent 1,000 emails in a 12-hour period on the 11th and 12th of July. And on the 1st of August, his behaviour continued with him seeking to add further allegations of fraudulent and criminal conduct and asked to add £150 million to the pleaded claim. By September, he was referring his intention to pursue allegations via PHSO, the Supreme Court, and the Metropolitan Police, as well as libel against one of the judges. Such allegations were repeated at the end of September, and in October he refused to attend the next hearing, as to do so would be to endorse the corrupt process. That's a quote. He then failed to attend the final hearing, and Judge Dawson says that the reason that I have set out such chronology is according to Mr. Akal's CV from the July 17. He was not only working for the MOD, he says, according to him, on complex PTSD cases, but also had responsibility for supervision of a psychologist and two assistants. I would expect, Judge Dawson says, that the contents of his CV will be checked to its face value, but his CV does not suggest that his expert witness practice commenced significantly after he accepted his significant mental health difficulties. Furthermore, more worrying, his CV records that in January 17, he founded and become clinical director of his own psychological consultation and med legal practice and started writing med legal reports. Now, so contemporaneous between all of that. And then at paragraph 24, Judge Dawson says that, unfortunately, the difficulties for Mr. Ackle don't stop there. His evidence has been criticised by a number of judges, and she reminded herself that they've all come to their own judgments. And those judgments range between 2022 and 23. At paragraph 26, Judge Dawson says that the central significance of these judgments is their timing. All three judgments have been delivered, and Mr. Akal accepts that he was aware of them and told me that he had sought to learn and improve from them at the time he assessed the claimants in the case of Basharat. And the central elements and the very direct criticisms of the previous judges relate to his willingness to diagnose PTSD without recording any detailed of the account or accident to justify the meeting of that criteria of a threat to life, personal injury, explaining how the criteria is met, or in fact demonstrating that he properly considered this and without reviewing medical records. So, Judge Dawson says that if, as he told me, Mr. Acker was aware of each of these criticisms from the judgments, and due to the timing, they should have been fresh in his mind, she would have expected to find these matters at the front and central to his reports in the Basharat case. They are not, Judge Dawson found. Um, and At paragraph 30, Mr. Acker further went on to set out the criteria for DSM-5 exactly as it was criticised by His Honour Judge Owens 6 months earlier. He then boldly stated that each criteria was met without further explanation or analysis. Now, you've got a summary there of the other points I've made. There are inconsistencies, most significant in terms of within the report of one of the claimants. Mr. Acker was putting both PTS and PTSD and confusing and inconsistent opinion and evidence altogether. And He was asked in cross-examination by myself, and paragraph 33, understandably, Mr. Acker was asked about this rather significant discrepancy in cross-examination and was unable to explain it other than as a mistake. A mistake, Judge Dawson finds, in the most crucial and significant part of the diagnosis is somewhat difficult to explain or for the court to understand. But she then says it's not an isolated incident. Therefore, and then she then goes on to talk about other points. There are significant concerns that this may be due to lack of care being taken with formulaic, produced copy-paste reports. And there is further in that judgment the issue of advocating for the claimants. And I'll let you read paragraphs 35, 36, 37. Wholesale advocating for the claimants in answers to part 35 within the reports, justifying his view, for example, as to why telephone examination is better than face-to-face or video. He relied on essentially in his estimation expert reports, sorry, not expert reports, academic guidance that was far outdated, which we've justified pre-COVID and pre-technology telephone examinations, whereas the more recent reports by authoritative bodies, including his own professional bodies, suggest that actually video would be better to see reactions rather than not. So you could see there that further at the very bottom, 'cause I'm running out of time now, there is also judicial recognition that a first-tier physiotherapist, as was the practice here, and is sadly commonly the practice in the volume area, really ought to be doing more than the claimants with more, mere soft tissue minor injuries, let alone psychological injuries, because it's inevitable that they're going to have to refer on to a psychologist, clearly in this case, such as Mr. Acker, who inevitably, as seemed to be here, would medicalize and diagnose and prognose a formal diagnosis rather than what could be simply, travel anxiety for a limited duration that a GP ought to be able to do routinely. So I also put there at the bottom another case of mine, in which the development of these areas of law, where the first judicial recognition of claims layering occurred, Khan and Aviva in 2022. See paragraph 36. So there you are, experts with duties, paramount to the court. Do the job properly, read the evidence, read the records. If you don't think you've got enough information, say so and wait for it and do it provisionally. But more importantly, your duty as an expert is to the court, not as an advocate for your party. Thank you. And if there are any questions, happy to deal with. Over to you, Rob.
Thanks very much. Okay, so I'm just going to switch to my slides. Hopefully that's going to cooperate. Yep, just a moment. You should all hopefully now be able to see a set of slides from. So yes, good afternoon, everyone. My name is Robert. I'm going to be taking you through 4 cases over the last 12 to 15 months or so in the credit hire sector that I think are of interest. And I'm going to be dealing with them in ascending order of significance or of the court dealt with them. The first of those cases is a case called Wiltshire and AI Nissan Dower Insurance Company of Europe. And the way I characterize this case is it's a good example of how not to run credit hire litigation from the point of view of a credit hire company or indeed the solicitor acting for them. So the start of this claim was straightforward. It was a simple road traffic accident. The defendants insured reversed into contact with the claimant's vehicle that could cause damage to it whilst he was on holiday in Wales. Liability was admitted. There was no personal injury, simply damage to the vehicle. So far, so straightforward. Matters then, as I put it, took a sinister turn. The claimant's oral evidence, which was accepted at trial, and when I make reference to things that actually happened, I refer to the claimant's own oral evidence, as opposed to his witness statement, for reasons I'll come to later, was that he telephoned his insurers to make a claim under his own full and comprehensive policy. He was concerned only with repairs to his vehicle and the provision of a replacement vehicle to allow him to return from his holiday in Wales to his home in Oxfordshire. However, his call was then transferred to a firm of solicitors specialising in bulk credit hire claims. That firm of solicitors also, they're going to remain nameless in this podcast, so it's easy enough for you to find in the citation. That firm of solicitors also controlled a credit hire company and provided a claim for him under a credit hire agreement. At no point was it made clear to the claimant that he was dealing with anyone other than his insurers. Had he known that, his evidence was simply come. It starts bad and it only gets worse. The claimant was provided with a replacement vehicle, which he believed was supplied by his insurers. He was told it was supplied by his insurers. In fact, it was a credit hire vehicle procured by an agreement with the firm of solicitors, between the firm of solicitors and the credit hire company which they controlled. The claimant denied credibly, the court found, signing anything other than a document relating to the condition of the hire vehicle at the time he took it over. He denied having signed a credit hire agreement, and the credit hire agreement set out terms on which he would have to pay a total of £500 per day, albeit on a credit basis, and that he would be liable for storage charges. So he denied, and the court accepted that he hadn't actually signed it. That leaves open the question of who did sign it and how it came to be signed. This goes to a trial. It's faced with a simple put-to-proof defence by the defendant's solicitors. At that trial, a witness statement purportedly by the claimant was produced. That witness statement contained the following observations: that the claimant had instructed the solicitors to pursue the claim, that they had advised him that they would be able to deal with the claim for vehicle damage, which includes assisting him with any additional services he needed, including such as credit hire, credit repair, credit hire, credit recovery and storage. He was aware that they offered a one-stop shop and could arrange everything on his behalf with no upfront cost. That is what he wanted, as using on hire meant that he did not have to go to the expense and hassle of trying to obtain multiple quotations from other providers of similar services. He was informed both orally and in writing that the directors of the solicitors were also directors of the credit card company, that they had a financial interest in the credit card company. He understood this and agreed to use the company. He was told that he could use alternative companies if he preferred. He did not wish to do so and agreed to use the services. An engineer would inspect his vehicle, and if it was damaged beyond repair or required repairs, the credit card company would provide him with a higher bill if he needed it. He was informed about the services that they would provide on a credit basis, which means he would not have to pay anything up front. He was advised that he would be liable for charges, but that they would be claimed against the at-fault driver as part of the claim. So on the face of it, so far so good. That resolves the concerns as he's raised up to that point. The problem was this, none of that was true, nor had he prepared, approved, or even previously seen the witness statement. The claimant was adamant that these were not his words and it was not his understanding, and the court accepted that. The wording of the statement were in fact copy-pasted from many similar examples produced by the same solicitors. So essentially every statement they produced in support of the higher charges claim contained the exact same wording, regardless of whether that was true. The claim had been pursued in respect of the higher charges of two different vehicles, whereas the claimant readily accepted that only one, in fact, had been supplied. The claimant appears to have had no involvement, in fact, with the proceedings prior to attendance of trial. And the judgment conspicuously does not say whether the claimant personally signed the witness statement or the particulars of claim, although it appeared to accept as evidence that he had signed nothing at all except a document related to the condition of the vehicle. So that then does leave open the question of who had signed the statements and particulars of claim, presumably purporting to either be the claimant or acting on his instructions, neither of which would appear to be true. The court found, unsurprisingly in circumstances, that the credit hire agreement was not enforceable against the claimant, and so dismissed the entirety of the claim for credit hire and storage. The claimant succeeded in his claim for loss of use of the vehicle for a 3-week period, and presumably vehicle damages had already been paid, although that's not entirely clear from the judgment itself. On the face of it, that was all he ever wanted in the first place. The credit hire claim was seen to enforce involved on his behalf. He had also effectively had the use of the credit hire vehicle for free at the offering company's expense, which lost an outlay of what it said was about £50,000. So the credit hire company, in some spectacular style, what the thing is put them there. The judgment does not say what the payment costs, and one wonders if there was not consideration of a wasted cost application of referral. So some fairly self-explanatory lessons here. That's a case where just about everything that could go wrong did go wrong. What I say to that is this. If you're sitting back, shaking your head and thinking, how did anyone ever get themselves into that position? Well, that's understandable. On the other hand, I wonder if some of those practices are a little bit more familiar than the grim totality. And I say this in the notes without wishing to be condescending. It's sometimes easy to lose sight of the fact that these cases belong to the claimants, and they actually have to be involved at each stage. And quite apart from the professional allegations, quite how the credit hire company thought it was ever going to get away with that in the long term beggars belief, because sooner or later they're going to run into a client who is excessively honest, as appears to have been the case here. As strange as that sounds as a way of putting it. So watch this space. The district judge said this. Many people unfamiliar with credit hire claims may question why the courts have not intervened in this industry, which, given the figures involved, paid out by insurers over the culpable motorists, must surely have an impact on rising motor insurance premiums. The answer to that may be that the senior courts have exhausted the arguments of common law and only new legislation by Parliament could alter the position, and whether that will happen remains to be seen. So do watch this space. One does wonder. Now, on to the next case that I want to look at today, of the first two. It's a case called Parker and Skyfire on the one hand, and Spectre on the other. This is a High Court decision from 2024, and I call it a good example of how to get away with some of these practices, disturbing though that might be. And it probably gives an insight into the answer to the judge's question in Wiltshire. I think he's probably right. This is a good example of how options other than legislation have been exhausted. So, excuse me. Parker and Skyfire starts fairly simple. The defendant drove into a collision with the claimant's vehicle, and liability was admitted. The third-party insurer defendant, I'm going to keep them nameless, but it's in the title of the case. I don't know anything about that. The third-party insurer defendant strongly suspects that in the course of the claimant's management, I beg your pardon, we can't put a slide out of order. So the claimant attempted to contact his insurers to obtain a replacement hire vehicle. A claims management company had adopted a practice known as Google spoofing, which means that it had created websites that falsely imitated the names of several well-known insurers, including the claimant's insurers, and had used search engine optimization to ensure that this false website came in the top of a list of Google searches ahead of the genuine website for the insurers. The claimant found and called this number, believing he was speaking to his insurers. He was set up with a vehicle on credit hire, again, under the belief that this was being provided by his insurers. He did, however, accept the offer of the car, but bear in mind at that time we believed it was being provided by his insurers, not on a credit hire basis. Now, the defendant insurer, in the circumstances, suspected that there must have been dishonesty and misleading in the course, simply by virtue of the facts of the circumstances in which this credit hire agreement arose. The defendant insurer suspected that there must have been misrepresentation in the course of engaging that credit hire agreement, entering into that credit hire agreement, and that had implications for the enforceability of the credit hire agreement, because if there had been misrepresentation, they said the agreement would be voidable for misrepresentation, and if the claimant were to avoid it, he would not be under any subsisting liability to pay the credit hire charges, and would not have suffered any corresponding loss. The defendant would accordingly be released of any obligation to indemnify them. However, the defendant could make no positive case to that effect other than to put the claimant to proof of the enforceability of the credit hire agreement, without disclosure of the recordings of the telephone call arising from the spoofed website. The pleaded defence, as I say, simply put the claim to proof. The claimant, obviously himself, being the only party, that not recorded the phone call, but the claims management company had. So the defendant applied for a non-party disclosure of that recording under CPR 3117. So the requirements of that provision are at 3173, and the court may make an order under this rule, which is to say a non-party disclosure order, only where the documents of which the disclosure is sought are likely to support the case of the applicant or adversely affect the case of one of the other parties, and the disclosure is necessary in order to dispose fairly of the claim or to save costs. So the application was refused at first instance, and the defendant appealed. The appeal, however, was dismissed. And the reasons for that were that, on the one hand, the court was satisfied that the first limb was made out, so that the disclosure sought might well support the defendant's case of misrepresentation, and accordingly well, and is accordingly likely to do so. It held that it was not a mere fishing expedition, perhaps not surprisingly, the first instance disagreed. I stress, however, saying that this is a decision which rests on the particular facts of the case, and that many of the other cases involving claims management and credit card companies, there is not sufficient evidence to satisfy the threshold condition of limit. So, however, that is not the end of it. Looking at the second limit, because the defendant must also satisfy the court that disclosure is necessary in order to dispose fairly of the claim of certain costs. So, even if there had been a misrepresentation, that did no more than render the credit hire agreement voidable rather than void on the claimant's own, I beg your pardon, on the defendant's own case. A voidable contract does not depend for its validity on whether, on whether it has been affirmed or not. It is valid unless and until it is avoided. So the correct question is therefore not whether the defendant has produced sufficient evidence of that affirmation, but whether the defendant can point to a real prospect that the contract is both capable of being avoided in principle, and if so, might in fact be avoided by the claimant. So there had to be some evidence that the claimant had avoided the contract by reason of misrepresentation. Not just that he might do so, but that he actually had done so. And it is that latter consideration to which the question of affirmation was primarily relevant. And as to this, the defendant lays much of the emphasis that there is no positive or direct evidence of affirmation. However, a contract can be affirmed by conduct as much as by express words or statements. The claimant had affirmed the contract by accepting the car. He might not have known of the misrepresentation at the time, so one wonders what relevance that has. But he was in attendance at the hearing below, and even if he was unaware at that stage, he might potentially have had a right to avoid the contract. He cannot have failed to grasp the point following the hearing, yet he continues to maintain his opposition to the application. So even faced with being told that he'd been misled, the claimant accepted the credit hire agreement, and so he hadn't avoided it. It was voidable rather than void. The appeal was accordingly dismissed because, in the absence of any appetite by the claimant to rescind or avoid the agreement, it did not matter if it was dishonestly obtained. So the district judge left with this remark: this and other cases, similar cases, turn a spotlight on what some clearly view as questionable practices by certain credit hire and claims management companies. This is a point which appears to have troubled Justice Constable, who considered the prevalence of these practices raised a new principle. Indeed, I was informed by counsel that the questions raised by this appeal are ones which, on which an authoritative decision is eagerly awaited. So again, that ends with a watch this space for the mark. Okay, moving on to the higher courts now. Tesha and Direct Access, Direct Accident Management Limited. This is a Court of Appeal case relating to third-party costs orders in credit hire cases. And I'm going to take these points rather straightforwardly because, firstly, I'm running short of time, and secondly, because it's a fairly straightforward point. So, very often, with all of these, the value of the claim is pursued in respect of sums that will be payable either directly to the credit hire company or in discharge of a liability that the claimant might have on the credit hire company. And the claimant might actually have very little interest of avoiding that liability personally in the proceedings. So in Wiltshire AI, the case we looked at earlier, for a claim worth about £52,000, about £50,000 represented credit hire and storage charges. So the Court of Appeal was asked to decide earlier this year if this fact exposed the credit hire company to third-party costs orders if the underlying claim fails. So the consequences are pretty obvious. CPR 4416, I'm sure will be familiar to most of you in this area, deals with exceptions to quotes. Orders for costs made against the claimant may be enforced up to the full extent of such orders with the permission of the court, and to the extent it considers just, where the proceedings include a claim which is made for the financial benefit of a other than a claimant and a dependent within the meaning of section 1.3 of the Federal Acts, and that's 1976, and made for the benefit of someone other than the claimant, other than the claim in respect of the duties of provision of care. And so where paragraph 2A applies, the court may, subject to Rule 46(2), make an order for costs against a person other than the claimant for whose financial benefit the whole or part of the claim was made. So one might think that exposes credit hire companies to such orders. That is solidified in the practice direction to Part 44. The court has the power to make an order for costs against a person other than the claimant under Section 51 of the Civil Courts Act. And the practice direction then sets out a list of considerations, but essentially it comes down to the court may do so if the claim was brought for the benefit of a third party, and if it considers it fair and just to do so. So in Tesher, the court was faced with two very similar examples where, on the one hand, virtually the whole value of the claim was pursued in respect of credit hire charges when the claim was unsuccessful, and the second where it was pursued in about 65% or about 65% worth of the damages. So the Court of Appeal did make two third-party costs orders disapplying quotes against the three credit hire companies, 100% of the defendant's costs and 65%. The question was the extent to which the credit hire company was the real party with tacit control over the litigation. What the court does is it sets out a list of considerations that it did not regard as significant. So the credit hire company did not decide whether to issue proceedings, weren't given copies of court documents, weren't informed about settlement and so forth. But that was not a significant factor in respect to tacit control of the litigation. The fact that terms were commonplace in the industry was not a relevant consideration. The fact of a close personal business relationship between the claimant solicitors and the credit company was not a relevant consideration. So, as in Wiltshire and AI insurance, it's not unusual for solicitors to own shares in the credit hire company, to be directors of it, to have a family linked to the credit hire company. But that isn't in and of itself sufficient to make out a liability for third-party costs orders. The fact that the claim would or might well have succeeded had it not been discontinued, faced with an allegation for fundamental dishonesty, was also not a relevant consideration. So it does beg the question, it seems to me, well, what is a relevant consideration? And the short answer to that is that the court is not as clear as might be the case. And critical as I have been of the credit hire companies in the first two cases that I looked at today, it's quite hard to see what had happened in Tesher that isn't routine, simply, or what went wrong simply beyond the fact of the credit hire company providing credit hire vehicle. So watch this space. It might be that those costs, third-party cost orders, become routine. I think if you're acting for a defendant, you should be considering making an application for those costs because it's quite a low threshold in Tesher. If you're acting for a credit hire company, be aware of the possibility and consider ATU insurance perhaps. But watch this space. I'm not quite sure what's going to happen there. But it could be that there'll be a more developed code of practice for when and in what circumstances cost orders should be made in the future. And last but by very no means least is Armstead and RSA insurance, which is a Supreme Court case from last year. It's one of these unusual but not non-existent Supreme Court cases with minimal value but key importance. The value at stake was £1,500 or so, 50, 60, I think. but it has very broad implications for the industry as a whole. So what had happened was that the claimant was, to quote, unlucky enough to be involved in 2 road traffic collisions within a short space of time, neither of which was her fault. So this takes a little explaining, so let me go through it at a slightly slower pace. The first accident caused damage to her vehicle. She obtained a replacement vehicle on credit hire. That credit hire agreement included a clause that if there were damage to the hire vehicle, which caused it to be out of action for a period of time, the claimant would pay the cost of repairs, and this is the important bit, up to 30 days hire in respect to the periods where the vehicle would be unavailable to the credit hire company. Is the clause 16 sum. So an estimate of the amount of time it would take to get repairs carried out was given, and the claimant would be on the card to pay up to 30 days hire in respect of that period of time. Then what you might have seen coming happen, the second car, the hire car, was damaged in an accident which was the defendant's fault, or the fault of the defendant's insured. The hire car was out of action for 12 days. The claimant sought to recover the cost of the repair and the clause 16 sum based on 30 days. And at first instance, the claim was refused on the basis that the claimant had no proprietary interest in the car and the loss was irrecoverable pure economic loss. So presumably the claimant had to pay those out of the property. The first appeal succeeded on the basis that, or in respect of the repairs, so the High Court held that it was not pure economic loss to seek to recover the repairs of the car, even if you had no proprietary interest in it. But the rest of the appeal failed in respect of the clause 16 sum, so that's your 30 days, on the basis it was unjust for the claimant to recover the clause 16 sum where only 12 days actual loss had been incurred. So one questions why 12 days was not successful, but there we are. There was an appeal to the Court of Appeal. The Court of Appeal dismissed that appeal on the basis that the clause 16 hire agreement was an internal arrangement between the bailey and the bailor, the claimant and the credit hire company, and as such, not on the basis for recovering losses from the third party. That clause 16 was not negotiated at arm's length and was not a true independent agreement between the credit hire and the claimant. The clause 16 did not represent a genuine reasonable attempt to assess the most likely losses to be incurred by the credit hire company as a result of the use of the hire car. The clause 16 liability was a form of irrecoverable pure economic loss. That clause 16 did not represent a genuine and unreasonable attempt to assess the likely losses incurred as a result of the loss of the hire car. And therefore, the loss was too remote to be recoverable. Quite a mouthful, but what you might expect is a bit of judgment on that area. The Supreme Court looks at this and says, no, all of that is wrong. The only one of those that has any legs in it, of various reasons given for rejecting the claim, the only one was in principle a legally valid reason. This was the loss was too remote to be recoverable because the clause 16 sum was not a reasonable estimate of the hire company's likely loss of revenue on the car was off the road. However, the defendant on whom the burden of proof lay did not plead or reduce any evidence to show that the clause 16 sum was not a reasonable estimate of the hire company's likely loss. In the absence of any such pleaded allegation or evidence, it was not open to the Court of Appeal to reject that ground. We would therefore allow the appeal and enter judgment in the claimant's favour for the clause 16 sum. So the sole requirement seems to be that the claim in those circumstances, well, firstly, it doesn't appear to be controversial that repairs are recoverable to a hire vehicle. The requirement in respect of off-road time is that there be a reasonable pre-estimate, some claim is a reasonable pre-estimate of the credit card company's actual outlay. It seems to me it's open to a defendant insurer to argue that those fees ought not to be. It seems it's open to me to the defendant insurer to argue by reference to comparator evidence that realistically these repairs are going to be done in 15 days or 7 days, whatever it is, and therefore a 30-day or a 60-day or a 45-day or whatever it is, time off the road is not a reasonable estimate. So that's what we're going to want to think about if you're acting for a defendant in a place like this. And it might be worth noting that the sums involved in this particular claim were wildly disproportionate to the effort put into this appeal. So one does not appeal lightly to the Supreme Court over £1,500. One appeals to the Supreme Court over matters that are likely to be of significance for some time to come, and which the insurer is anticipating it to be of significance of some time to come. So watch this space. It's clear the insurers, I suspect, knew what they were talking about here, and that it was worth putting in this sort of time and effort. And that's it from me. So thank you very much for your attention. I'm going to see if there's any questions I've missed. I'm going to stop sharing. So the observation was made was that the Supreme Court had refused permission to appeal in Tesha. Yes, I think that is right. We're not going to hear anything more on Tesha, but I wonder if we're not going to hear anything more from the higher courts of the Court of Appeal on defining the circumstances in which third-party costs orders are going to be made. Roger may have a view on that. I don't know what to make of that yet, but watch this space. And there's a comment, had a similar case last week with the same solicitors and the credit card company struck out on a similar set of circumstances. Yeah, it's not an unusual practice. And I'm not above saying that I've had regular clients who've had a similar arrangement in the past. It begs belief that there's not regulatory action on this, and that it isn't for government. There's a major belief, a major breach. I don't know. It seems to be tolerated. But there we
Okay.
are.
Thank you very much, Robert. Very enlightening and informative. And I'm sure as far as Tesha and the associated applications for permission to the Supreme Court are concerned, defendants will be singing for the Supremes, and claimants probably not. But in any event, we thank you for your attention today. I know it's nearly lunchtime. I haven't really direct questions to answer, but feel free to email us directly through our class if you wish. And just to let you know then, I've just had some good news on the emails while you were speaking, that Chambers and partners have ranked Decker Chambers civil fraud and credit hire team in motor insurance fraud yet again. It ranked in Chambers and Partners 2026. So that's hot off the press. We thank you. We offer national service coverage. I live in the north, but Chambers is in London, and we cover the jurisdiction. Have a good day, everybody, and thank you for your time.